Hi everyone, in this video we're going to be looking at the Koompahtoo and Sanpine case, which is one of our key termination for breach cases. Okay. All right, so I mentioned that this is one of the key cases that looks at the right to terminate. So it confirms that the breach of an essential term gives rise to the right to terminate. It gives an analysis of repudiation or renunciation, and it also is the case that confirmed that the Hong Kong first shipping approach of intermediate terms is law in Australia, which is a breach of a term that causes substantial loss. But as you'll see in a moment, the judges weren't necessarily 100% in agreement on the usefulness of the intermediate term concept, which you'll see in the Kirby judgment. So this case involved a joint venture between Koompahtoo, which was the landowner, and Sanpine, which was the manager of this joint venture development project for the redevelopment of land at Morisset, so south of Newcastle. Now, the joint venture was entered into in 1997. However, after a period of time had passed, so 5 years, Sanpine hadn't obtained the rezoning approval, okay, which meant that the development of the land couldn't go ahead, and they'd also committed a range of contract breaches. These breaches were discovered when an administrator was appointed in 2003. Now, in terms of the breaches of the joint venture obligations committed by Sanpine, they include unexplained expenses, banking irregularities, improper documentation, and records. And then in 2003, in December, the administrator terminated the joint venture agreement on the basis of these breaches. Sanpine, however, wanted the contract to continue on foot, so they disputed the termination. So the key question here became whether the termination on the basis of those series of breaches, none of which themselves were a condition, okay, so none of them themselves being an essential term, whether that right to terminate arose and was therefore validly exercised. So the issue that went before the High Court was whether Sanpine's actions amounted to a breach of contract such as to justify the termination of the contract by Koompahtoo's administrator. At trial, Justice Campbell found that there were 3 types of breaches. So the breaches themselves weren't an issue here. That was clearly established. It was only whether those breaches gave rise to the right to terminate. And you can see those examples of the breaches on the slide here. And at trial, the judge said that the termination was valid. There were sufficiently serious breaches of intermediate terms. Now, the concept of intermediate terms was found or made out in the Hong Kong first shipping case, which was an English Court of Appeal judgment. And in that case, they explored this concept of whether a term is condition or a warranty, and stated that that approach was, insufficiently flexible to deal with all the circumstances in which a right to terminate should arise. So a breach of a warranty gives right to arise to damages, but not a right to terminate, whereas a breach of a condition or an essential term gives right to arise to does give rise to a right to terminate. Now, in Australia, that approach had been cited with approval, but it had never actually been part of the ratio of a case before Koompahtoo. So it hadn't been affirmed as law in Australia. So we'll have a look at what the High Court found. Okay, so the High Court here agreed with the trial judge's assessment of the issue in this case. And it was stated that, the breaches here were gross and the consequences were serious. So as a matter of construction, and I'm quoting here from the slide, so as a matter of construction of the contract, it ought to be accepted that breaches of that order deprived Koompahtoo of a substantial part of the benefit for which it contracted, i.e. the breach went to the root, or the series of breaches went to the root of the contract, and that because of that, such breaches justified termination. So it looked at the seriousness of the breaches of what were warranties and said that in these cases, these terms were an intermediate term that justified the termination here. In finding in this way and in approving of the concept of intermediate terms and that reasoning in Hong Kong for shipping, the case stands for authority that a serious breach of an intermediate term can lead to termination or can result in termination. And you can see a quote for that at 54 of the judgment. So the breaches of this kind are sometimes described as going to the root of the contract. Okay, so taking into account the nature of the contract and the relationship it creates, the nature of the term, the kind and degree of the breach. Okay, so the seriousness of the breach is relevant, and the consequences of that breach for the other party. So in circumstances where there is a serious breach, even if those terms themselves, looking at them from the outset of the contract, they were only warranties, they will still be held to be intermediate terms because, taking into account this range of factors, the breach goes to the nature of the contract and the relationship it creates. All right, so in terms of the case reading guide questions here, okay, so who was suing whom for what? Okay, so here Sanpine was actually seeking a declaration that the termination by the administrator of Koompahtoo was invalid, okay, because they wanted the contract to still be on foot. Now, what breaches were alleged by Koompahtoo to have been committed by Sanpine? So you can see they're summarised at 24 of the judgment. And if you also have a look at 26, you can see the characterisation of those terms. The breaches included inadequate documentation, lack of records, banking records not kept as required. There was potentially some misappropriation of money as well. Inadequate bookkeeping, financial statements wrong, no cash books, etc. And you remember here that Sanpine was the manager of the project. So this is not just the fact that they failed to record one receipt. This is a number of errors here that were made by them, okay? Right, and errors that were breaches, obviously, of their duties under the contract. One thing I should have mentioned on the previous slide when talking about the facts was that there was no termination procedure noted in the contract, the joint venture agreement between the parties. Okay, so that's why we were looking at whether the right to terminate arose by law. So just insert that comment about 3 minutes ago. Okay, anyway, moving on. Okay, how did the trial judge characterise these breaches? At 26, there's discussion of this as mentioned. So the trial judge characterised them as relating to various obligations under the contract. Okay, so the obligations concerning the rezoning, banking and spending of money. And so those breaches were regular and they were systematic and failure to obtain proper records. Okay, so question 3 then. So what 3 circumstances did the majority describe as justifying termination for breach by the innocent party? So breach of an essential term, a sufficiently serious breach of a non-essential term, so an intermediate term, which is what these terms are considered here, and repudiation or renunciation. Now, here, the High Court actually only saw the first 2 things as relevant here. So breach of an essential term and sufficiently serious breach of a non-essential term, so intermediate terms. So they decided the case based on intermediate terms after determining that they weren't conditions here. Now, repudiation or renunciation wasn't seen to be relevant on the facts. And this position of the High Court differed from the Court of Appeal, who'd held by that there was no renunciation of the contract by Sanpine. And part of that is that Sanpine very obviously and very clearly wanted the contract to keep going, okay? So, yeah, just leave that there. But if you want to have a look at that in more detail, you can have a look at 61. Now, Koompahtoo themselves actually alleged that Sanpine had repudiated the contract. But did the trial judge or the High Court agree with this analysis? No, they did not. Okay, so the trial judge expressed their conclusions by reference to intermediate terms. And he actually said nothing about renunciation at all, and he made no finding about the intention evinced by Sanpine. You can see that at 56. The High Court also decided the matter on the question of intermediate terms and whether the breach of the term was sufficiently serious to justify Koompahtoo's decision to terminate. Okay, and then that obviously varies, as mentioned, to the Court of Appeal's approach, who decided the case by asking whether or not Sanpine had repudiated the contract. Now, the majority of the New South Wales Court of Appeal did hold that Sanpine had not repudiated the contract. And the High Court actually criticises the reasoning of the Court of Appeal. They state that the focus of the Court of Appeal's attention should have been on the nature and seriousness of the breaches. Okay, so those considerations that are relevant to whether it's an intermediate term justifies termination. And so they said that the attention should have been on that rather than whether the conduct of Sanpine evidenced an intention to perform the agreement only in the matter that suited it. So the Court of Appeal focused overly on the conduct of Sanpine in, I guess, wanting the contract to continue to be on foot, although they were going hell for leather in 10 different ways and weren't actually doing the things they were supposed to be doing. And so, yeah, the High Court said that the focus should not have been on Sanpine's conduct in that respect, but on the nature and seriousness of the breaches that they were continually committing. Okay, you can see that discussion at 68. So how did the majority characterise the consequences of the breaches of the contract committed by Sanpine? As I mentioned earlier, they saw the breaches as gross and the consequences as serious. So they went to the root of the contract. Breaches of the nature that were experienced here in this case deprived Koompahtoo of a substantial part of the benefit for which it had contracted, remembering that Sanpine was supposed to be managing this project. And because of that, the breaches justified termination. You can see that discussion at 71. Now moving on to the final question, which is on this slide. Justice Kirby agrees with the result, but actually disagreed with the taxonomy of circumstances justifying termination. Okay, so Justice Kirby was not such a fan of the intermediate terms analysis. Now, the two taxonomies that are discussed in the judgment of Kirby. The first is the right to terminate based on breach of an essential term, repudiation, or a sufficiently serious breach of an intermediate term. Okay, and that was the approach of the majority judgment. And the second taxonomy, which is the one that Kirby prefers, is where there's a right to terminate based on breach of an essential term, repudiation in the sense of renunciation, so the first two things are the same, or a breach of a non-essential term causing substantial loss of benefit. Okay, so Justice Kirby preferred the second characterization, and you can see that at 114 of the judgment. Now, in order to know whether you agree with how Justice Kirby sees these issues, you need to understand what his criticisms are of the concept of intermediate terms. For Justice Kirby, he identified that the concept of intermediate or innominate terms represent a classic instance of very circular reasoning, because according to him, you can't classify a term as an intermediate term until there's an analysis of the seriousness of the breach, which happens after the breach has occurred. So it's not, the classification of a term as an intermediate term is not on anything you can know at the start of the contract. And because of that, you know, it's not an objective analysis, it's more of a subjective analysis. So it's imposed retrospectively, which makes sense because you are focusing on the seriousness of the breach. You are focusing on the consequences of that. And you can't know that objectively at the outset of the time of contracting. So therefore, you know, the analysis really rests on the evidence that's used at trial. And this is what Justice Kirby objected to, because it renders uncertain this distinction between the categories, because you can't know if something's intermediate until later. So there's no internal characteristics of the clause which state that it's an intermediate clause. Now, it just here, you know, so from Justice Kirby's point of view, this analysis of intermediate terms from Hong Kong shipping was introduced into Australia without actually serious consideration of these issues. Now, in the majority's view, an intermediate term is breached where there's default in respect to the non-essential term, and where that non-essential breach of that term is so significant it goes to the root of the contract. And where a breach goes to the root of a contract, that depends on the nature of the contract and the relationship it creates, the nature of the term, the kind and degree of the breach, consequence of the breach, and where damages would provide appropriate relief in all the circumstances. And because this happens after the breach has occurred, according to Kirby, it means there's no clear basis for recognising or separating intermediate terms from non-essential terms prior to adjudication by the court. And he sees that as just simply creating confusion. I don't particularly find it that confusing though. It's just a non-essential. So all you have to do is figure out if it's an essential term or non-essential term that was breached. And then once you look at whether it's a non-essential, like once you've decided that it's a non-essential term, you just look at what the effect of the breach is. You know, conceptually, I see Justice Kirby's criticisms, but I think in terms of what we do, in terms of applying the law, I feel like it's relatively straightforward. But anyway, he does object to it as being, the concept of intermediate terms being vague and artificial, which I suppose it is, but, you know, I'm fine with that. But whether you are might be another question. Yeah, I'll just finish there. So have a look at Justice Kirby's reasoning around 107, 108. Think about whether you agree with his criticisms or not, and also just think through what it means for you in terms of your problem solving. Okay, so intermediate terms does add another step to the process of determining whether a right to terminate arises, but you know, I think you'll be fine with that. All right. Thank you, everybody.